Hello, my name is James Pantling-Skeet and I am a community care specialist at Leicester Aldridge Solicitors. This is the second webinar as part of a series that I'm providing in collaboration with the Brain Injury Group in order to explain, or rather to attempt to explain, the implications of the Coronavirus Act 2020, the coronavirus regulations, and the government guidance on accessing education, health, and social care during the coronavirus emergency period. I should also point out that inevitably this pandemic has some implications for how we manage dealing with mental capacity matters and managing people's affairs, and so this will form a distinct topic as part of a further webinar that's going to form part of this series. If you have not already done so, I would strongly recommend that you watch the first webinar that is also available on the Brain Injury Group's website, in which I have provided a quick overview of all the areas in which the new legislation is likely to have an impact, and I have explained the simplified hospital discharge process and the changes to accessing NHS continuing health care and NHS funded care for adults during the emergency period. I will not cover these issues in detail as part of this webinar because this second webinar is going to focus solely on accessing local authority funded social care during the emergency period. My hope is that by providing this series of webinars, we will be able to empower patients, families, and their representatives to navigate their way through the complexities this crisis creates. It is worth pointing out, before I go any further, that if you have any queries as a result of watching this webinar, or indeed any of the other webinars that are going to be made available on the Brain Injury Group's website, please submit them by email to inquiries@braininjurygroup.co.uk, and we hope to be able to record a follow-up question and answer webinar in which I will attempt to respond and answer as many of those questions as we possibly can. I should also point out that for future reference, that email address should appear in the bottom right-hand corner of all of the slides throughout all of these webinars. I've listed on the slide below the key legislation and guidance which relates to the changes to accessing NHS and local authority funded care during the coronavirus emergency period. I'm not going to give a verbatim oral account of all of these pieces of legislation and guidance. However, it's there should anyone want to Google it after listening to this webinar. In the context of the focus of this webinar on local authority funded care, the key things that you need to familiarise yourself with are the Care Act easements guidance for local authorities. So before I go into detail in terms of explaining what's changed as a result of the new legislation and the implications those changes are likely to have for accessing local authority funded social care during the coronavirus emergency period, it is probably useful for me to give a quick overview or reminder of the current position. So some of us may already be aware that under the existing provisions in the Care Act 2014, local authorities have a statutory duty, and the important word there is duty, to meet an individual's assessed care and support needs if that individual can demonstrate they satisfy the eligibility criteria and that they are ordinarily resident in the local authority's area. The eligibility criteria requires the individual to show through a needs assessment process that they cannot achieve 2 or more of the so-called specified care outcomes. Those care outcomes include things like the ability to maintain a habitable home, the ability to attend to personal care needs, or the ability to maintain and prepare meals and manage your nutrition needs. Once an individual has demonstrated that they meet the eligibility criteria and that they are ordinarily resident in the local authority's area, then the local authority has a statutory duty to ensure that that person's care needs are met, albeit that any care and support that is required to meet those assessed needs is subject to means testing rules. I've not set out on the slide what those means testing rules are at this stage. However, I will ensure that on the Brain Injury Group's website, we make available some resources which explain the means rules in more detail and provide an overview of how the financial assessment process would ordinarily work. But essentially, what you need to understand at this point, for the purposes of this webinar, is that whilst a local authority has a duty to make sure that an individual's needs are being met, it does not have a duty to fund that support ordinarily under the Care Act unless an individual satisfies the means testing rules. It is also worth pointing out that there is some statutory guidance which is quite a useful document at explaining some of the key provisions within the Care Act. So the changes that the Coronavirus Act 2020 and the subsequent Care Act easements guidance have made become legally effective from the 31st of March 2020. However, it is worth pointing out that those changes were not actually implemented as a result of the regulations that were issued following the Act until the Care Act easements guidance was subsequently published. So what are the key changes that you need to be aware of? Well, firstly, please don't panic. It is not the case that as a result of the Coronavirus Act 2020, the regulations and the subsequent Care Act easements guidance, that a local authority can decide from this point onwards that it will no longer do anything to meet anyone's needs. In fact, actually, whilst at first glance, the Coronavirus Act 2020 was a real cause for concern, and indeed many disability rights organisations wrote into the government and MPs expressing their concern about the very detrimental impact the changes were likely to have on the rights of disabled people across the country who are so dependent on this support. I would say that actually the subsequent Care Act easements guidance seems to be an attempt in some ways to water down the potentially rather far-reaching consequences these changes are going to have on the ability to access local authority-funded social care during the emergency period. So following on from that, under the Care Act easements guidance which has been published, if a local authority has taken steps to activate what are termed the easement provisions provided for within the Coronavirus Act 2020 as listed in the relevant schedule and the regulations, then the following changes will happen. Once the local authority has followed the process, which I'm going to explain shortly, to activate those easement provisions, and not until they have followed that process and a decision has been taken with evidence that it is necessary to activate the easement provisions, a local authority will then not need to comply with the following fundamental Care Act 2014 statutory duties. And those are as follows: the duty to assess care needs, the duty to assess the care needs of a carer, the duty to give a written record of an assessment, the duty to complete annual reviews, the duty to give effect to a preferred place of accommodation, i.e. a choice, and the duty to conduct a financial assessment before care and support services are provided. So they're the kind of headline key changes you really do need to be aware of, albeit there are some others. And I should probably point out also, before I go any further, that some of these duties are not suspended in their entirety. So, for example, whilst the duty to complete annual reviews during the emergency period where a local authority has taken the decision to activate the easement provisions has been suspended, if a local authority subsequently decides to complete a review, they must do so with regard to due process, i.e. the individual, the family representative and an advocate should be involved, and a written decision should follow to explain the reasoning behind any decisions that may come as a result of an annual review. My hope is that the failure to suspend some of those safeguards will protect vulnerable adults from the imposition of stealth cuts by local authorities. So I've structured the rest of this presentation around what I think are going to be the frequently asked questions as a result of this new legislation. So firstly, are all the pre-amendment Care Act 2014 duties suspended with immediate effect? Well, as I've already alluded to, no. The answer is no. A local authority cannot, I can repeat, cannot simply decide that from the 31st of March 2020, they will no longer comply with their Care Act 2014 statutory duties. there is a very clear expectation in the Care Act easements guidance that local authorities should continue operating on the basis of business as usual. And I've nicknamed it for ease BAU. So business as usual, or BAU, should continue until such time as the criteria or threshold for initiating the decision-making process a local authority must follow in order to activate the easement provisions is met. Now, the Care Act easements guidance doesn't reference or term the paragraph I'm about to show you as a criteria or a threshold, but I would argue that in reality, it is the criteria or threshold that a local authority is going to need to comply with or demonstrate in order to evidence their decision to activate the easement provisions. I've listed there on the slide, just in case anybody finds it useful, where they can find the regulations and guidance that support the easement provisions and the subsequent amendments that they make to the Care Act 2014 statutory duties, where a local authority has followed the process to activate those easement provisions. And it's probably just worth pointing out quickly that the Care Act easements guidance, as I think I've already mentioned, that was issued for local authorities under Regulation 2, is the guidance that gives effect to the changes set out in Schedule 12 of the Coronavirus Act 2012. And it is that Schedule 12 which set out all of the amendments to the Care Act duties. It is also worth pointing out that there are different rules for accessing social care in Wales, and indeed Wales have already taken steps to change the way people are to access care prior to the action that we took to implement these changes in England, and I am not going to cover these as part of this webinar. My hope is that I will be in a position to provide at least an article explaining the changes in Wales in due course, if this would be useful. So really, the starting point in order to understand what's likely to happen if you're trying to access local authority funded social care is going to be with reference to the Care Act easements guidance that I've already mentioned. And the key theme that you really need to take away from the guidance is that it is very much designed to afford local authorities discretion, 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 discretion. The expectation under the guidance, however, is that local authorities will follow the designated process that I'm going to explain shortly to activate the easement provisions in response to changes in local resources and to ensure that ultimately they can continue to meet local needs during the coronavirus emergency period. Obviously, this represents a major, very significant departure from the Care Act 2014 national duties and assessment processes that we are all used to. And indeed, as I mentioned earlier, during the process in which the coronavirus bill was being debated in Parliament before the Act was passed, a number of disability rights organisations were lobbying about their concerns at the vulnerable position this may leave adults in. And indeed, in the House of Lords, there were some rather damning and very critical comments raised by the likes of Baroness Gray Thompson about the implications that these changes would have for anyone seeking to access care. I'm remembering, as we speak about this now, comments made along the lines of it being a social care obliteration bill. So the guidance is likely to lead to variations of approach across England, and as I've already mentioned, it doesn't apply to Wales because there is a separate system in Wales, which I'm not going to cover as part of this webinar. What does easement provisions mean? And the answer is it's the term or phrase that's been adopted by the Department for Health and Social Care to describe the process and powers that are available to a local authority to deviate from the usual Care Act 2014 assessment duties and processes that we're all familiar with. The guidance is very clear, however, that local authorities should do everything they can do to continue meeting their existing duties prior to the Coronavirus Act 2020 coming into force. And this is where I mentioned earlier that I felt, or I do feel, and I think this view is shared by a number of other legal commentators in this area, that the guidance really seems to be an attempt in some ways to mitigate or water down the consequences of the Coronavirus Act 2020, and in effect, it seems to be a bit of an attempt to address some of the very serious concerns that were raised when the bill was going through Parliament. In relation to the easement provisions, the guidance states they are time limited and are therefore to be used as narrowly as possible. So what is the threshold for when a local authority can instigate using the easement provisions to relax the specified Care Act 2014 obligations? And I say specified because it's worth pointing out that it is not the case under this legislation and the guidance and regulations that the entirety of the Care Act has been disapplied. In fact, actually some fundamental provisions of the Care Act remain in force. For example, the Section 1 well-being principle remains alive and kicking regardless of whether a local authority has followed the right process in order to activate the easement provisions or not. Now, as I said, the guidance doesn't really term this as a threshold or a criteria. However, if you read the paragraph that I've put onto the slide, I think you'll agree that really it seems to be what a local authority is expected to use in order to decide whether they have reached the point at which it's going to be necessary to activate those easement provisions. So the guidance states, a local authority should only take a decision to begin exercising the easements to the Care Act 2014 provisions when the workforce is significantly depleted or demand on social care has increased to an extent that it is no longer reasonably practicable, and I would suggest the phrase no longer reasonably practicable is going to be crucial for it to comply with its Care Act duties as they stand prior to the Coronavirus Act 2020, and where to continue to do so is likely to result in urgent or acute needs not being met, potentially risking life. So I think out of that whole very wordy paragraph, the key things you need to bear in mind is that according to this guidance, a local authority is likely to have met the threshold where it may want to instigate the easement provisions at such time as the workforce is significantly depleted, there's been a significant increase on the demand for social care, and those factors, either or both, mean that it is no longer reasonably practicable for the local authority to continue to provide social care support in the way it ordinarily would do by virtue of the Care Act 2014. And if it were to continue to provide business as usual, it's going to result in urgent or acute needs not being met, which in turn will pose a risk to life. Any change resulting from such a decision should be proportionate to the circumstances in a particular local authority. So by this, I think it's really a further caveat to say that even if a local authority takes the decision that it is necessary to activate these easement provisions if those criteria, the criteria I've referenced, is met, there's still an expectation that the local authorities will take a further step or to consider or review what changes it needs to make in a proportionate and reasonable analysis before doing so, because it might be that actually they don't need to come away from all of the pre-amendment Care Act 2014 duties in order to continue to meet need. So, for example, it may be the case that by suspending completing annual reviews, that is sufficient to free up resources to enable local authorities to continue to assess whether they need to meet an individual's needs on the basis of the duty to meet need as opposed to the power. I think what we can take away from the guidance at this stage is that very evidently the intention is it should be business as usual, BAU, for as long as is reasonably possible. So there is a process for the local authority to decide that it needs to activate the easement provisions, and to be clear, once again, I'm going to point out that until the process has been followed to evidence that this decision to activate the easement provisions is required and the threshold I've referred to previously, so this paragraph here on the previous slide, has been met with reference to evidence, a local authority must continue to comply with its Care Act 2014 statutory duties as per the original enactment, and the Coronavirus Act 2020 doesn't alter them unless they have followed this process and reached the decision to activate the easement provisions. Once the local authority reaches this situation and it needs to activate the easement provisions, it's a decision that's got to be taken locally. It must be agreed by the Director of Adult Social Services in conjunction with the principal social worker. The Health and Wellbeing Board should be kept informed, and a discussion should take place with local NHS bodies. So this isn't a decision which local authorities are expected or should be making in isolation from their health and social care partners that they work with locally. It's very much expected that some form of consultation or discussion will be taking place between all of the local health and social care partners involved. All of the decision-making process and discussions that take place in order to reach the decision should be documented in a record, and that record really should reference the evidence that's been taken into account in order to reach that decision. And obviously that document, I would say, is probably going to need to directly reference the criteria that I mentioned previously, i.e. this paragraph here. Once the decision's been reached and it's been documented and recorded in this way and this process has been followed, the decision to activate those easement provisions must be communicated to all providers, service users and carers. The guidance also suggests that the written record of the decision, i.e. the decision to activate these easement provisions, should reference the following factors. And these are factors which a local authority should take into account when reaching this decision. And those factors include the nature of the changes to the demand or the workforce, the steps that have been taken to mitigate against the need for this to happen, i.e. the need to operate under the easement provisions rather than complying with standard Care Act 2014 statutory duties as a usual course of practice, the expected impact of the measures taken, how the changes will help to avoid breaches of human rights at a population level. And so I would argue that that would mean how it will help to minimise the impact across all of the service users a local authority is responsible for. The individuals involved in the decision-making process, i.e. who has the local authority discussed about this and were the relevant people involved before the decision was reached, and the points at which this decision will be reviewed again. And I would suggest this guidance is therefore making it quite clear that even if the decision is taken to activate the easement provisions, there is no expectation in this guidance that once easement has been activated, a local authority can continue to act under those easement provisions in an open-ended way. Actually, it's quite clear that the guidance is going to be encouraging local authorities to deactivate those easement provisions as soon as the resources allow them to do so. And I think if you consider those factors against the threshold or the criteria that I've talked about already for when easement should be considered, really those factors just draw out some of the key themes that I've mentioned about this paragraph here. A local authority should only take the decision with reference to the significantly depleted workforce, etc. The factors I've just referenced there clearly just draw out some of those key points and are hoping, it seems to me, that the guidance is hoping that by including those factors, local authorities will really give this criteria some really quite deep thought. So, assuming a local authority has reached the point where they meet that statutory criteria, well, it's not statutory, the criteria in the guidance that's obviously issued under the statutory provisions, I should correct myself there. So once that's been met, this decision-making process has been followed that I've just talked about here. These factors have been considered, and it's resulted in a decision to activate the easement provisions. The Coronavirus Act 2020 and the subsequent regulations and guidance provides that once they've reached that point and a local authority is under easement, they do not have to comply with the following Care Act 2014 statutory duties. And these are the duties that I mentioned at the start. So the duty to assess needs, to assess the needs of a carer, to give a written record of an assessment, to complete annual reviews, to give effect to a preferred place of accommodation, and to conduct a financial assessment before services are provided. So I'm going to quickly gallop through some of those duties and how they're going to be affected by the Coronavirus Act amendments once easement is instigated or activated. So the duty to assess the needs of an individual and the needs of a carer. So under the pre-amendment situation, so i.e. under the Care Act 2014, we had this duty to meet a person's assessed needs if they met the eligibility criteria and they were ordinarily resident in that local authority's area. and the same applied for a carer's assessment as well. However, that duty is suspended, and the same applies to the duty to carers. Instead, the local authority will have a power, not a duty, and it's important to take that point away. It's a power, not a duty, once the local authority is acting under easements, to meet an individual or a carer's needs for support, unless, and this is a really important caveat and safeguard here, a failure to meet those care and support needs would breach the individual's human rights. So, sort of breaking that down a little bit, there is still a duty, I would say, under the new legislation and the easement guidance to meet an individual or a carer's needs for care and support, if failing to do so would breach an individual's human rights. If the answer to that is there would be no breach of the individual's human rights, then the duty to meet need falls away and instead becomes a power to meet need. And obviously the word power evidently suggests that it is far more discretionary in nature. There is no compulsion to meet need like we have at the moment with the pre-amendment duty. Another really important feature to point out is that the duty to complete a full needs assessment and prepare a care and support plan in the way that we would be familiar with under the Care Act 2014 has been suspended. Instead, the Care Act easements guidance suggests that local authorities will be expected to make an assessment of needs. And I think it will remain to be seen whether this make an assessment of needs suggestion is really going to help things, because there is no guidance as to what that assessment should include. The so-called assessment of needs that guidance references, albeit it's not going to be the same as we would ordinarily have, should be made with a process that involves the individual, i.e. the person that's going to be receiving the care, family members, and all of that should inform care planning with the care providers as well. I think it's fair to say that the assessment of needs that takes place when a local authority is acting under the easement provisions is not going to consider a person's needs in the level of detail that we would ordinarily expect for a standard Care Act 2014 needs assessment. But as I've already mentioned, I think it's questionable whether this watered down version of a needs assessment is really going to save time and is really going to help local authorities deciding how to prioritise meeting the care and support needs of those affected during the coronavirus pandemic. It seems to me that a watered down version of a needs assessment is likely to lead confusion and is going to require local authorities individually to decide how they're going to assess needs and how they're going to document it in a way that differs from the norm, but is less labour intensive than they would ordinarily do. Any decisions made about whether or not to exercise a power to meet needs, so if the threshold for breaching human rights isn't reached and the duty to meet need is then downgraded to a power to meet care and support needs, those decisions should be made on the basis of proportionality and reasonableness, based on evidence and with reference to the new ethical framework for adult social care. And this ethical framework has been put together to set out some very broad brush general principles that local authorities are likely to, are required, to have regard to in decision-making processes before reaching a decision. Because they are broad brush general principles, quite clearly they're going to afford local authorities a huge amount of discretion in any decision-making that takes place whilst the local authority is operating under the easement provisions once that decision's been reached. The principles and values, to give you an idea, that the ethical framework for adult social care promotes are as follows: respect, reasonableness, minimising harm, inclusiveness, accountability, flexibility, proportionality, and community. And so I think you can already see, just from looking at those at first glance, that these are very broad brush principles, and how they are to be applied in practice is obviously going to be something that remains to be seen. Another key question, which a lot of people I think are struggling with already, is the issue of charging. So as I mentioned at the start, under the pre-amendment Care Act 2014 standard statutory duties, once it had been demonstrated that an individual had care and support needs, they met the eligibility criteria, and they were ordinarily or deemed to be ordinarily resident in the local authority's area, there was then a duty placed on the local authority to meet that person's care and support needs in whatever way the care and support planning process determined to be appropriate. But it's subject to means testing rules. And so by this, I mean that any care and support that was provided would not necessarily be funded by the local authority, because if they did not satisfy the means testing threshold, then the individual would be a self-funder, i.e. they would have to pay for the cost of any care required to meet those needs themselves out of their own funds. In some circumstances, depending on where they fell within the means testing threshold or scale, they may have been required to contribute to the cost of the care. And in some circumstances, obviously, that the local authority would fund more of it, or the entirety of the package, depending on where they fell within that means testing threshold scale. Under the Coronavirus Act 2020 rules and the subsequent regulations and guidance, local authorities are not required, I repeat, not required to charge for care and support that's provided during the emergency period. This means, in theory, you could be given or awarded a package of social care at no cost to you at first instance. However, please note that a local authority can complete a financial assessment in order to raise charges against you despite this rule. I guess a safeguard, at least, is that a local authority is not going to be permitted under these rules, or is not permitted rather under these rules, to raise any charges without completing some form of a financial assessment beforehand. My suggestion is that given that resources are going to be tight whilst public bodies focus on responding to the needs of the pandemic, it is unlikely that many local authorities during the emergency period will complete full financial assessments, and most of them are probably going to conduct these assessments on the basis of the light touch financial assessment concept that the pre-amendment Care Act 2014 and the statutory guidance already provided for. A light touch financial assessment simply means that in some cases, a local authority may choose to treat a person as if a full financial assessment has been carried out. But in order to do that, the local authority must be satisfied on the basis of evidence provided by the person that they can afford and will continue to afford any charges due. So just be very mindful of the fact that free care does not necessarily mean free care, and you may be retrospectively charged for anything that you've received. And continuing on that theme of charging, the issue of retrospective charging is that where a local authority does not conduct a financial assessment at the outset of the package, the new legislation, regulations and guidance do give the power to a local authority to retrospectively assess at any time during the emergency period or within a so-called reasonable time after the emergency period is over. There is therefore a power to retrospectively charge for any care and support that's put in place. And so just because you are given a package of care free of charge during the emergency period does not mean that that will continue in the future. There is unfortunately very little guidance at this stage as to how retrospective charging is going to operate in practice, and I imagine a number of care providers are going to be worrying about how they're going to deal with funding disputes as and when resources allow for people's finances to be considered, because it seems to me that there's going to be quite a high risk that people may be placing care and support that under normal rules they would not be able to afford if they don't satisfy the means testing thresholds. So really, I think taking a step back a moment, in view of the possibility that a local authority may retrospectively charge you for any social care support provided during the emergency period, it would be advisable, when considering care and support options that may be available to meet an individual's needs, to approach it on the basis of the general principles that we're all familiar with, i.e. consider whether you are a self-funder, and if you are unlikely to satisfy the means testing rules and fall within that self-funding category, bear in mind whether you can afford the cost of the care and support packages being put in front of you to consider on that basis, because it is highly likely that at some point in the future you will be charged for the cost of that package, and you may also be retrospectively charged for any care provided previously. The duties relating to providing a choice of accommodation are going to be suspended or modified And as I've explained in the first webinar, in which I covered the changes to the hospital discharge process, where we now have the simplified discharge to assess process with a focus on discharging patients the same day that they are deemed medically fit and safe for discharge, the usual rules relating to the choice of accommodation are not going to apply. So whilst what this means is that if there are 2 or 3 potential options and the patient's preferred choice is not available within a reasonable timescale, the local authority and NHS bodies that are involved will be able to basically encourage you to be discharged to the option which is available, even if it is not the patient's preferred choice. And the idea is that as and when the patient's preferred choice becomes available, if at that point the patient still requires care and support, arrangements should be made to transfer the patient to their preferred choice of care and support. I question, however, whether in reality there's going to be enough resources to facilitate that follow-up taking place. The duties relating to annual reviews are suspended. So for any local authority that is acting under these easement provisions, if a local authority will not be required to complete annual reviews during the emergency period, again, as a measure to enable it to prioritise meeting the needs of people during the pandemic. However, there is nothing stopping a local authority from completing an annual review if its resources allow it to do so. So importantly, it's worth pointing out that the duties and safeguards that are in place in Section 27 still remain the case. They've not been suspended because the section was not disapplied in full. So if a local authority decides to embark on a review of an existing care package, they must involve the patient or the individual, family members, and an advocate if an advocate is required. And there is a process which should be followed before a decision is made. And so I would strongly advise that if you are advised by a local authority that they wish to review your package, that you make sure that they are aware that it should be completed in accordance with due process. Another big issue, which I think all of us is going to be sitting here thinking, how on earth is this going to work out in practice, is how will a local authority decide if a failure to meet care and support needs would breach a person's human rights? And actually, I think this is going to be something which a lot of local authorities will really struggle with, because human rights law is extremely complicated, and I'm not sure that social workers on the front line are going to be equipped in order to make this determination. In order to consider responding to this question or making this decision, and obviously this decision is going to be quite crucial because, as I've mentioned, it is only if a failure to meet care and support needs, once the local authority is acting under the easement provisions, is likely to result in a breach of human rights, that the local authority will still have a duty to meet that person's needs as opposed to a power. If the failure to meet needs is not going to result in a breach of that individual's human rights, that duty will be downgraded to a power. So in order to determine this issue, there's going to need to be regard to the European Convention on Human Rights, and the rights that are particularly important in this context are likely to be Article 2, the right to life, Article 3, the right to freedom from inhumane and degrading treatment, and Article 8, right to private and family life. Unfortunately, though, I am yet to see any guidance as to how social workers on the front line are going to be expected to make an assessment of whether a failure to meet need is likely to breach human rights. And again, I think this is going to be something which many frontline workers are really going to struggle with. In theory, human rights could be breached by failing to provide services such as adequate toileting facilities, access to fresh food and water, or access to assistance with meeting your personal care needs. However, I would urge caution here and point out that in order to demonstrate a breach of human rights, you're going to need evidence in the form of an assessment which shows what a person needs to keep them safe and what the reasonably foreseeable consequences are of that situation. And in particular, the reasonably foreseeable consequences are for the person's physical health and psychological well-being of not providing care and support or withdrawing any existing care and support package that may be in place. Now, in theory, that seems like that would be relatively easy to satisfy in a lot of cases. However, the threshold for demonstrating a breach of human rights in the context of care and support provision is actually quite high based on existing law. Nevertheless, the fact that we are currently all living under a government-imposed lockdown which restricts our liberty may impact how that threshold is likely to be applied if any of these decisions result in challenges being brought before the courts. Just also be aware that the decisions made by a local authority who may be acting under the easement provisions to provide additional care and support during this time that perhaps they ordinarily wouldn't provide are not going to be binding forever. And so it may be the case that in the future, packages of care and support are withdrawn once they are reviewed. And can a local authority's decision following the assessment be challenged? Well, the answer is yes, of course, and the guidance actually makes it very clear that local authorities are expected to have a very clear and transparent pathway for concerns to be raised. But again, this is where there's a very big element of discretion afforded to local authorities in the guidance. And so you're going to need to check with your local authority what their local policy is going to be for resolving concerns about care and support decision making. I would say that you could utilise complaints procedures, but I'm aware that already local authorities and NHS bodies across the country have started to suspend their complaints procedures in order to redeploy resources to the front line. I'm also aware that the local government ombudsman has suspended handling complaints during the coronavirus emergency period as well. That does not, however, prevent you in the absence of a complaints procedure or a unsatisfactory resolution through following the local pathway from considering whether a challenge needs to be brought before the courts. Any decisions that are made by a local authority are acting under the easement provisions still need to comply with general public law duties. And I should point out that even if a local authority isn't acting under the easement provisions and they're continuing to make decisions under the pre-amendment Care Act 2014 duties, these general public law duties still remain. And that's obviously the duties to comply with human rights obligations, for any decisions made to be lawful, and for any decisions made to be rational, proportionate, and fair. In addition, any decisions made need to comply with obligations imposed on public bodies, whether that's NHS bodies or local authorities or both, by virtue of the Equality Act 2010. And here I'm thinking of the obligations to prevent direct or indirect discrimination. And also that if any policy, particularly in the context of formulating policies on how to respond to this issue, making sure that local authorities and NHS bodies comply with the public sector equality duty imposed by Section 149 of the Equality Act. And another fundamental principle which has not been disapplied and so remains in force regardless of whether a local authority is acting under the Care Act 2014 or under the easement provisions is the Section 1 wellbeing duty. So I mentioned this at the start, but it's actually a really important principle because Section 1 of the Care Act places a duty on local authorities to make sure that they promote an individual's well-being. And then the relevant subsection of Section 1 gives a list of what is likely to be considered to be meant by well-being or is included. And so things like a person's emotional well-being fall within that list or that definition. And so if you can demonstrate that failing to provide care and support needs is likely to result in the local authority failing to promote that individual's well-being, that could be another way of arguing that the decision is wrong. Ultimately, if you exhaust the local complaints procedure or policy that your responsible local authority puts in place in order to raise concerns, if a complaints procedure or process has been suspended, and you do not have the ability to resort to the local government ombudsman to resolve your concerns, there is the possibility that you can consider taking action by way of judicial review. However, there is a pre-action protocol that has to be followed, and before you take those steps, it is strongly advised that you take legal advice. Another concern that a number of people have already raised with me is, can providers be forced to accept patients if they cannot meet their needs? And the answer is no. Providers must be given, and the guidance is very clear on this point, and that's the Care Act Easements Guidance, sufficient information about a person's needs in order to determine whether they can safely meet their needs before accepting a placement. And this is probably going to be most problematic for patients being discharged on the simplified discharge to assess model under the new hospital discharge rules. Any person who is assessed is entitled to a copy of the assessment, as are their family or representative. And there is a clear expectation in the guidance that a copy of the assessment will be shared with individuals and their families or representatives. And any assessment that you're provided should be sufficient to evidence the decision that's been made, demonstrate the exercise of professional judgment that those local authority social workers have made, and also it should apply the ethical framework for adult social care, which are those broad brush principles I mentioned earlier. It's also worth pointing out that a local authority's safeguarding duties by virtue of Section 42 of the Care Act 2014 have not been suspended, and so they remain in place. There are no changes to the duty of a local authority in relation to safeguarding. So that concludes my very quick gallop through the changes that the Coronavirus Act 2020, the coronavirus regulations, and the subsequent guidance has on the ability of people to access local authority funded social care for adults during the coronavirus emergency period, and concludes the second webinar, which is going to form part of this series of webinars I'm providing in collaboration with the Brain Injury Group. If this webinar has left you with questions that I have not answered through the content or the information I've provided, please do email any inquiries or questions you have to inquiries@braininjurygroup.co.uk, and a follow-up question and answer webinar will be held shortly, in which I will attempt to answer as many of those questions as I possibly can. Thank you for listening.